So for everybody out there that's watching today, hi everybody, good morning. Good morning. Thank you. So welcome to our 33rd program of this year. Amazing considering we did 31 all of last year and we still have another 6 to go. But good morning and welcome to this MSVN News Annual Symposium. And for those that don't know, this is already our 5th annual symposium. So again, I want to thank you all for being here. We have a very good crowd here today and I'm really happy to see all these tables nice and full. And we have a lot of people that are watching this on live stream today and I'm thankful for all of you too. So I'm saying hello and thanks for being here. Before I continue, I want to thank for the opportunity to give to our sponsors and those that gave us education grants to do this program. Because without their assistance, these programs that we do is not possible. So, firstly, I want to thank Genzyme, a Santa Fe company, who's the maker of Aubagio. We want to give them a round of applause and thank them for doing this for us today. We also have Mallinckrodt Pharmaceuticals, also previously known as Questcor Pharmaceuticals. They make the Acthar gel that's used for many of you who have relapse. Teva Neuroscience, the maker of Copaxone, who now switched to that 3-day-a-week formula. It's a 40-milligram formula. So we want to thank them for all their help. Genentech, who's a company that none of you know the medication of yet. They have something in the works, hopefully an emerging therapy, and you'll hear about it today from our speakers. Also, other sponsors are Neuroscience Centers of Florida Foundation, Accorda Therapeutics, Biogen IDEC, Bionis, Pfizer, Infinity Research, and Neuroscience Consultants. Again, let's give them all a round of applause because we cannot do these programs without them. And believe me, they want you to learn. Okay, they are helping us because they really want you to learn more about MS. They want your caregivers knowing about it. So, again, I thank them for all they're doing. So, as we continue, let's welcome our final speaker of the day, and that is Craig Dorne. And Craig will be speaking about caregiver responsibilities, caregiver rights, caregiver this, caregiver that.
All right, good afternoon, everybody. I'm here to talk about all of those things you want to know about, but you're afraid to ask. All of those things that you continue to avoid, and all of those things that scare you. So that's the cheerful part. That's why they saved me for the end. But I don't think most people realize what the rights are and what the obligations are of a caregiver, and that's really what I'm here to speak about. I'm going to be a little bit different than all of our other speakers because I'm not going to save the Q&A to the end. So if you have any questions as we go along, I want you to feel free to ask because we're also catching you at the end of the day and I don't want to miss any of the questions. And my topics do have a habit of jumping all over. To let you know a little bit about myself, I am a Florida licensed attorney. So for those of you that are asking questions about other states, I can only speak in general terms because I'm only licensed in the state of Florida. And for those of you that are online, note that even though the points I'm talking about are based upon Florida law, it's very similar in any state that you might be in. Because our laws are somewhat similar, but some of the phrases that I'll be using might be worded slightly differently in your state. To let you know a little bit more about myself, I've been practicing law for about 25 years, and my area of practice focuses mostly on transactional matters, but I've also done some different businesses throughout the years as part of my practice of law, including forming HMOs all around the United States, so my healthcare knowledge is pretty good as well. So if you have any questions, please jump in, ask at any point in time. I do not mind being interrupted, and I don't mind answering pretty much any question that you want to ask. I don't have any cards with me because I don't think I can have enough cards in my office to handle everybody. But you can always get my information from MSVN News. My office is right in Coral Gables, but I do practice throughout the entire state. Okay, we got questions already. Does anybody have a mic that's ready to start walking yet? Okay, we got Pat. Pat's ready to jump in.
I don't need a mic. I think I talk loud enough for myself. It's like, my question is, we're trying to round up a listing of a lot of people that have MS and they have their
There is absolutely no reason that a spouse cannot be a caregiver.
Okay, when we tried to look that up and find out what was the cause of a spouse, my husband being able to be a caregiver was it was an immediate relative. That's the answer that we got. And we want to know how do we get our spouses registered as a caregiver to where if they were to have to leave their jobs and become our total caregivers, where do we go?
That's basis under the FMLA. There's a lot of other laws that also exist in each of the states that give you the rights to take care of your spouse. That's what those laws were designed to take care of. So whoever's giving you that information, it's totally inaccurate. Everybody can be a caregiver. It can be a stranger. It can be a family member.
Okay, but our question will be, would that caregiver have a reimbursement since they have to leave their job to take care
It's dependent upon state and federal law as to whether they would have the right to continue to be paid. Most of the FMLA things that you're going to be getting is not going to be getting a paid position. It's going to give you the right to leave your employment and continue to keep your position, but it's not going to guarantee you to be paid during that period of time.
Okay, so that's the answer to my question, meaning that, let's say that would be one less income coming, but that spouse dedicates their self to it, would they have to then become like full registered caregiver and be shown as?
It's dependent upon whatever insurance or benefits that you might have, that they might have the ability to seek some payment for what they're doing, but it's not going to be replacing their pay that they're receiving. It's just going to be an alternative source of funding. If you have, let's say, some type of insurance that would cover to give your spouse to enable them to receive compensation for what they're doing. I think that's really where you're heading. But they're not going to have the right to continue to get paid by their employer while they're taking care of you as a caregiver. I think you're talking about the requirements under a specific insurance policy. And that's going to be dependent upon whatever insurance you have as to who would qualify to be able to seek reimbursement for taking care of you under that insurance policy. But that's not a legal perspective, that's a contractual perspective based upon the insurance policy.
Yeah, no, the reason is because I was checking on the website, getting information, and a spouse could be a caregiver if there's no income coming into that caregiver. But there was a section saying if that spouse has to receive an income, it cannot be your spouse.
That's based upon your contractual rights of your insurance policy, where generally what they're trying to do is avoid fraud and abuse where the spouse is becoming the caregiver under the insurance policy. But that's a different type of a caregiver. That's actually somebody that's taking care of you for reimbursement from your insurance policy. And generally they're not going to allow that to be your spouse because your spouse is ordinarily there anyhow.
So you're telling me it has to go through my insurance?
I think that's what everybody's talking about here, is based upon getting a reimbursement check that's covering you for somebody being a paid caregiver. But that's not something you're going to be getting based upon employment or something along those lines that's going to allow you under the FMLA to have an exception from work and continue to get paid. They're two totally different topics. Family Medical Leave Act. The Family Medical Leave Act is what FMLA stands for, and that's a federal law. But that's also dependent on the slides that I'll be getting into in a little bit that will give you the information on that. What am I here to talk about? A lot of different subjects.
Yes, I wanted to find out. My husband and I, we have wills, we have advance directives, and we have power of attorneys for each other. Would I need anything else? Do you suggest because of his condition?
One other form that I'll be talking about in just a few minutes.
Okay.
But let's talk about what a caregiver really is. A caregiver is somebody that's there to help out somebody who is in need. That caregiver can be a family member. That caregiver can be a stranger. That caregiver can be a paid person. What we really have to understand, though, is what are those caregivers' rights and what are those persons' obligations. Now, whether a caregiver is a family member or a stranger, they really have the same rights and obligations. But they're also, as a paid person, can also have some different legal obligations, such as a breach of contract and things like that, that also understand that they have obligations that can actually stem on a legal perspective. So you have to understand that that caregiver is there, but the caregiver also has to understand what he or she can do for you. And many of those things are dependent upon what rights you actually give that person. You also have to understand that if you're expecting somebody to be your caregiver, that you're actually going to have to be coming out and expressing what it is that you want that person to do, to make sure that that person is willing to do what you want them to. Because we'll find that when we start dealing with things in life, that there are certain people that are better at other things and certain people that are better at what you want them to do. We have to understand what that person is committing to and whether they're really willing to accept that position. Most people like to hide from the inevitable. But whether you have MS or whether you're a 20-year-old that just got married and is starting to have children, all of us have rights and obligations to each other, and we have to understand who is the best person to take care of that. I remember when I first started practicing law. Here I am, a young person, pretty much think that I know everything, only to find that when I started working and I became number 326 on the totem pole of all the lawyers inside the firm, that I really know a lot less than I thought I did. And I got called in by a senior attorney inside that office that started asking me a bunch of questions. And I said, who is this person? Why are they asking me these questions? And it seems to be awfully personal. Only to find out that she knows that attorneys, like anybody else, we have a habit of putting off the inevitable and not wanting to face things also. Such as, well, you're married now. You're getting ready to have children. Who's going to be the personal representative of your estate? Who's going to be the guardian of your children? And all those things really need to be put on paper. Because if they're not put on paper, nobody really has those rights, and the person that's going to make that decision for you is a judge. Do we really want a judge to make up the decisions for us? Do we really want to start and have strife and arguments amongst our family as to who the people are that have the rights? And is that person that the judge ultimately decides the one that we want to have make those decisions for us? And when I had that conversation with her, he said, you know what? Here I am. I'm young. I'm in good shape. I think I was about 70 pounds less then. And I never thought that anything really could affect me. Yet when we sit down and think of things, every one of us have lost people at young ages and things like that also. So we need to make sure that we really do protect ourselves from the inevitable. The most important thing that every one of us can do, outside of taking care of our children and taking care of our families, is to make sure that we can take care of ourselves. And there is a little form that is out there. And for those of you that are here in Florida, you can actually go on to the Florida Bar website and download that form for free. You don't have to pay an attorney to do certain things. And one of those forms is called a healthcare surrogate. To me, that is the most important document that every person in this room should have, where we actually disclose to everybody who it is that we want to make the decisions for us when we're not capable of making that decision ourselves. So depending upon what state you're in, it's typically called a healthcare surrogate or a healthcare proxy in other states. We can complete that form and we can give somebody the legal right to make that decision for us. Otherwise, you go to the doctor's office and you're there, and let's say you're not capable of making the decision, something happens. You go to the hospital, you can't make that decision. You're not sure what to do. You're having one of those senior moments or whatever else it might be that we all have a habit of experience, or the MS moment, however you want to word it. Isn't it nice to sit down and actually know that we have this form, it's completed, and the doctor can actually make the call to the person to help guide in your health care? No, it does not, at least in the state of Florida. All it requires is to have certain people fill out the form. It's right there on the website. And as I said again, it's free. Yes. I can't see that far back out there. So right now, the people in the front get the benefit. I can see everything.
The person that I want to be my healthcare surrogate is my daughter. She lives out of the country. Is that a bad idea?
It's not a bad idea, but the problem you're going to have is some doctors might be reluctant to honor that because they're not going to know who the person is on the phone when they're trying to make that decision.
Even if
How do you know who it is you're talking to on the phone? The general purpose of the healthcare surrogate form is to have somebody that they can speak to because you cannot speak for yourself. So if that person's out of the country and they're trying to do that, they're going to call, but I think a lot of doctors might be very reluctant, so that means if somebody else of your family happens to be there, I think it's more likely that they're going to honor the person that's in front of them versus the person that's out of the country. And that's not saying that that's legal, but if you have the conversation, but 99 times out of 100 when that healthcare surrogate form kicks in, it's when you're in the hospital and when it's really needed the most, and the person that's going to be in front of the doctor is going to be the person that they're probably going to speak to, even though that's not the person that you want to have speak for you. And that's the general problem, is that you're going to find the person, you need to really designate who that person is that's going to honor your wishes. because it is the healthcare surrogate's form, and I should say the healthcare surrogate's obligation, to sit down and do what you want, not necessarily what they want. Which I'm saying is that's why you want to pick the person that's actually going to honor your wishes versus their own. I have family members, and one in particular, I won't mention who it is, especially since it's being recorded, that would absolutely not honor another family member's wish. And I'm sure we all have people that are like that. We're convinced 100% when the spouse passes away that they're going to want to have the spouse mummified and kept there because they're never going to let this person go.
He has literally threatened me with that.
But if you complete the healthcare surrogate form, it doesn't necessarily have to be a family member. It could be somebody else who is a friend of yours that will honor your wishes, that will have the ability to be designated that is here. There is no legal obligation for that person to be a family member. You can make whoever it is that you want. It can be your next door neighbor. It can be your best friend. It could sit down and technically you can have things that are done where it can be another doctor, if a doctor would assume that position. There are healthcare advocates and other people that are out there that are paid advocates that might be willing to accept the position as being a healthcare surrogate. Question right over here in the white shirt, then I'll get the one that's right behind it.
Can there be more than one healthcare surrogate on the form? Like, if that person can't be-
The healthcare surrogate generally will have a first person and then an alternative if that first person is not available. But let's say you have two healthcare surrogate forms that are out there, and they're two separate ones with naming two different people. What they're going to generally look at is whichever one was completed last, saying that that one's going to overrule the one that was before it. So you don't want to have different people that are going to sit down and necessarily conflict with each other, but let's say you have two children and their positions are exactly the same for you. I have drafted actually two documents, that way one person is there or the other person's there, but the fear is still if they get to be in conflict with each other, in which case the latter one will rule.
But you can have the first person's out of the country.
Then they have an alternative that they can speak to, and yes, that's generally the way that it is. It will actually have a listing in sequential sequence as to this person, then this person, then this person. Kind of like you would have a personal representative in a will. It's this person, then this person, or guardian, etc. There was a question that was back there.
Yes, my question is just if you have someone, you said it's free, the form. You download it and you have to do something else. You have to make it legal. So
All you have to do is complete the form, and I would present it to my doctors, so that way your doctor will have it, so that it's there of record, so the doctor will always know. You would want to give it to somebody that they have the ability to bring it to the hospital. God forbid that you're admitted to the hospital and you don't have the ability to complete the forms when you're there. A normal thing, when you get admitted to a hospital, they're actually going to ask you to complete certain forms if they don't already have it on file, one of which would be the healthcare surrogate form or healthcare proxy.
the form is legal and they have to take it.
They're going to need to see it, so therefore it's going to have to be a document that is fully executed. They're not going to take somebody's word that they're your healthcare surrogate. All they would do is be deferring to the family member based upon general things, saying, well, they want to speak to your spouse or your children, depending upon who is the closest relative to you that shows up at the hospital. But again, that's really not what we want to have happen, because one, they may not necessarily know who that person is, or two, the doctors might just do whatever they think is best if you're incapacitated at the time. Question in the back of the room, I see.
I think what the issue might be is once the form is downloaded and filled out, does it need to be notarized for it to become a legal document?
There is no requirement on the form for it to be notarized.
Thank you.
I think there was a question all the way in the back.
Hi. So you mentioned that a friend could actually be this person that is the healthcare surrogate.
Yes.
So my lawyer told me that that is only true if the friend resides in Florida.
I think what you're talking about is not pertaining to a healthcare surrogate form, but I think what you're talking about is pertaining to actually a will. Inside a will, your personal representative must be a blood relative if it's residing out of the state, but inside of the state, it can be anybody. But on a healthcare surrogate form, that person does not necessarily have to reside in the state to be serving as your healthcare surrogate. But in a will, it's a totally different picture. The person needs to be a resident of the state or a blood relative. And the blood relative only goes out so far. Okay, we'll see if I can make actually my second slide. I have no problem. I'm a professor on the side, and I have a habit of just going off and paying absolutely no attention to my PowerPoint presentation that I got ahead of time to go give my lecture also. I go off on tangents, and then you can't shut me up, which is why I'm the only one scheduled to speak for an hour. Because Stuart at one time had me giving a speech over on the West Coast, and it was scheduled for a half an hour, and I think I actually went about an hour and a half. And I don't think I made it past the third slide in that one either. But as a healthcare surrogate, you have to understand that you have a right to sit down and do certain things. We have the right to sit down and also get that information, which is another important part, because how many of you go to a doctor's office, we all understand these little forms called HIPAA privacy laws. Very important thing for everybody to understand, which means the doctor cannot speak to anybody unless you give written authorization for that person to speak to you. Now, it's a little bit different. We all sit down, and I go crazy every time I go into a hospital and I'm sitting there listening to a doctor talking to a patient, and I can overhear the conversation. We all love how good our privacy rights really are. I think every hospital should be required to have these little private rooms that you can go into and actually talk, so we can do that, but that's not realistic either. But we need to sit down and know that if we do complete the proper forms, the doctor has the right to speak to that person. You can actually give that person the right. We need to give people the right to be able to speak and take care of us. But if we don't have the forms completed, the doctor is speaking to us, and unless you're as compulsive as a certain relative of mine is that actually goes with her little notepad and has every question that she wants to have answered, we all realize we have our moments. Wouldn't it be nice to sit down and have somebody else to have the ability to speak on our behalf? We can do that, so prior to you going to your meeting with your doctor, maybe somebody can actually send some information over on your behalf and have the ability to talk to the doctor, especially if that person is out of state. It would be nice if all of us have somebody that can go with us and be with us at every single doctor appointment. I realize that that is not a realistic thing. So we want to actually designate and give people the right to speak on our behalf and take care of some of the privacy requirements that the doctor might have so they can actually start to communicate, assuming that we have a doctor who's willing to actually talk. No offense to any doctors that might still be around here, but it seems like we go to our visits, we don't necessarily get the time that we would all like, and that's based upon our reimbursement levels, that they can't get that and they have to see more people than they really should. Also, why we have so many doctors that don't come into the practice anymore that would be our future doctors, because the money isn't as good as it used to be. But we do have email communication. We do have other ways that we can start doing things. And I know that some of the doctors that are here do have the ability to actually communicate with us by email and other things too. Try to sit down and document, or give somebody the authorization to document on your behalf and communicate on your behalf. Let that person have the ability to act as your advocate. I am the world's greatest person at fighting for people. I am the absolute world's worst person to fight for myself. I've had people that have not treated me right, that have not done things. I'll pick on a car dealership, since I do that all the time in my classes when I teach. My daughter's car caught on fire because it wasn't properly repaired. Did I go after them for the depreciation and value? No. Did I have every right to have the ability to do so? Yes. If it was one of my clients, would I have done it for them? Yes. So we need to make sure we choose the right people that will fight for us. Act as an advocate. If you do not fight for yourself, get somebody and give that person authorization to fight for you. That can be your healthcare proxy. That can be a professionally paid healthcare advocate. There's actually, the University of Miami created a healthcare advocacy program because there's so much of a need of people out there that you can actually get professional people to do it on your behalf as well. So again, choose the right person to do it, and you may choose to choose a professional versus one of your family members to sit down and take care of that role for you. Now, part of taking care of the caregiver is also for the caregiver to take care of himself or herself. They need to make sure that they have the ability to take time off, go away, rest, relax, or just as most of the modern people say, the word chill. If that person doesn't do that, how are they going to have the ability to sit down and truly advocate for you? So understand that the healthcare advocate also has to have the ability to sit down and take time off. So what do I recommend for all people that are in need? You need to have more than one person. That can also help you when you don't have the ability to help yourself. It can't be a 24-hour a day, 7-day a week, 365 or 366 on a leap year basis job. So you need to make sure that when you get to that point in time that there is somebody else who can fill in and help. they have the right also to be treated with respect. So if you actually have your healthcare advocate and the doctor doesn't start blowing that person off, that healthcare advocate does have the right to be treated with respect and be listened to as well. Now for the healthcare advocates, not patients that are sitting out here, or our healthcare surrogates, understand that you have to make sure that you truly understand what is going on. Every one of us have the ability, and every one of us lie. I can't tell you the number of times that I hear about a relative or somebody who is being taken care of that will not tell the truth. Not too long ago, I buried one of the lawyers who I worked with for a number of years. His answer for how is everything, it's fine. I'm perfect. I have no issues. I take one pill, it's my multivitamin. I knew it wasn't the truth because he refused to face the facts. Notwithstanding the fact that he was 6'3" and probably close to 400 pounds, everything was perfect. I have no issues because he was blind. His family knew nothing. After he was discharged from the hospital, he was in there for almost nothing. I just went in for a couple of days. He blew up part of his heart valve. But yes, he's fine. There are no issues. Because why? People manipulate people. People hide from facts. You want to make sure that you actually are truthful and honest with whoever it is that's taking care of you. Because if you are not truthful and honest with the person that's supposed to be taking care of you, how can they take care of you? The fact that you want to not burden that person, you don't want to tell them the truth when you are not feeling well. How is that person going to help you if you are not honest? So choose the right person to fill the role. If you are afraid to tell that person the truth, that person should not be doing the job, or you have to face the facts that you need to tell them the truth. Do not conceal information. Do not hide information, because how are you going to be taken care of? No questions coming up on that, because nobody's willing to admit the truth on that one. Okay, we got one brave soul. Thank you.
Actually, I'm going to just backtrack on you a little bit, but it was my understanding that a spouse is automatically entitled to find out any information on the patient?
Absolutely not true.
Okay, not true. So you got to have the properly executed documents then?
Diplomatically saying this, we will find doctors that will communicate with people. Some of the doctors will not pay attention to their own HIPAA policies and procedures. But the truth of the matter is, your spouse does not have the right to know everything. There are certain things that are written statutorily into the law. Like, a wife cannot go sit down and have her tubes tied without the permission of a spouse, because that's a right that's given by the law. But that does not mean that the spouse has the right to know everything about you. If you want your spouse to know everything about you, give a form and give a power of attorney, or give a healthcare surrogate form, give something out there that gives the right for the doctor to communicate with your spouse. But otherwise, if I was to go to my wife's doctor and start asking for information, is he going to talk to me? Absolutely not. He was one of the people giving a lecture here today. I know he will not. So understand what your rights are. But if you want somebody to know about you, give them the right. If you don't want them to know about you, don't give them the right. Let them think that they have the right. Yes, right in the front.
Just to emphasize what you said, I had a relative who concealed the fact that he fell. Of course, when the toilet broke, it was hard to conceal it, but what was never given up as forthright information was the fact that the toilet was broken with his head. So with the end result, and MS people do lose their balance a lot, but what ended up happening was
The hemorrhage.
to remove a subdural hematoma, and it was necessary to have a neurosurgeon remove the blood clot from the head, and then after that it was a matter of hallucinations and pneumonia and continued bleeding. And the other thing was that there's another document people should have, and that is
Durable power of attorney?
no, that one, and there's another one, and do not resuscitate.
DNRs. I'm going to get there also if I don't run out of time first. That's about slide number 12. I think I'll get there eventually.
Craig, I got a question back here.
Okay.
Yes, hi. I think it was a previous slide, and I appreciate all of the things that you're saying that we as the MSers shouldn't do. But the part about the caretakers needing to know their own limits and to take breaks, you know, because that also is a problem in the aspects that, in my experience, is they tend to not want to take a break. And they want to be there constantly, almost like a stalker.
It is a real... It is a real problem. We have our spouses, domestic partners, however you want to word it. We have people that want to take care of us, our children. Or we may want to have the stranger that wants to take care of us because they know about all the money we have in our bank account, which is a whole nother category of people that we need to be aware of. I can't tell you the number of times I have gotten calls from people that I've had to refer out to probate attorneys or other people that can sit down and do a will contest because somebody came in as our caregiver that all of a sudden takes over our entire inheritance. So there are a lot of other things that we need to be aware of that has a habit of happening. That's why I say everything that we don't want to know about is what I'm going to talk about. Yes, that does come up. Those are real issues that we need to deal with. So if you don't want to have your family member taking care of you that you want to inherit, well, we need to make sure that whoever is taking care of our family members when we are on the other side of it doesn't take advantage. I'll give you a real life hypothetical that happened. So I'll talk about it in a hypothetical fashion, but it's true. We have two brothers. One brother who was the brother that needed to be taken care of because he had a drug abuse problem. We had another brother that was a banker who did very well for himself and had a couple $1 million in the bank. The brother that needed to be taken care of moved in the house and was helping mom, although he was really just being taken care of himself. And then that brother somehow gets the person to go over to the attorney and sit down and complete the wills and the documents and do a title change to the house so that the other who needed to be taken care of got the house when mom passed away. Is it right or is it wrong? We don't know, which is why we also need to be honest with our family members as to what we want to have taken care of. Because now we have two brothers that don't talk to each other and ended up in some nasty court litigation as to whether the person was of sane mind when the documents were created. But if we do all these things and we discuss these things openly and honestly, well, perhaps mom just wanted to take care of that brother because he really needed the house, where the other person had all of the money and didn't really need it. But will we ever really know if we do not communicate? We do have people that will be taken advantage of. I can't tell you how often it happens where I just sat down and helped somebody sell their mother's condo and all of a sudden he's trying to take care of the financial information for the estate, seeing that a whole bunch of money was leaving the estate because she had a paid caregiver who was going to the bank and taking out all of the money. These things happen. Welcome to Miami. Welcome to whatever city you might be in. There are a lot of dishonest people that are out there also that may seem to be the nicest, sweetest people in taking care of our family members. Question up front. No, one behind you.
Okay, let's say you have a family, one sibling takes care of the parent. Parent in their will or trust leaves everything equally to the siblings. The other siblings while the parent is alive and being taken care of by one of their siblings have a right to an accounting while the parent is alive and evidently incompetent.
Okay, we have two siblings that are there that are being treated equally inside of a will, but what happens during the period of time when one sibling might be taking care of the estate? Does the other child have a right to an accounting? The answer is pretty much no. Because if you want to give somebody the power to do an accounting and seeing what's going on beforehand, you better give that sibling what's called a power of attorney to sit down and have the ability to go over things. We can give while we're alive, we have a form called a power of attorney. It's a legal document, it's notarized. If you want to do it correctly, because there are a lot of laws that are being passed in different states to make sure that we're not giving away global rights, we want to give away specific rights. And if we want to make it global, we do it paragraph by paragraph by paragraph. Or what I do when I create my power of attorneys, I actually have a 12-page document of powers, and I require my client to initial paragraph by paragraph by paragraph as to each power they want to give. And if there's not an initial in there, that means they didn't want to give that power over. But realize also that we give the power of attorney, it's only good while that person is alive. Once you give this power of attorney, it's a nice, lovely legal document, but once our family member passes away, that power of attorney is now a worthless piece of paper because the power of attorney dies when the person dies. Because all it does is give them the power to speak for them while they are alive. After that, the will kicks in. So if you want somebody to have a right to do an accounting, go to your bank accounts and start getting certain information, then you need to give them the power of attorney to get that information. Insofar as after you pass away, if you believe that there was embezzlement or whatever else it was, the child could technically go into probate court and try to get some kind of accounting rights to see what's happened in the account before, but it's not exactly a great power to have because you may not really have the ability to do anything about it.
What about if there's a trust involved and everything's under the name of the trust, like a local trust, and that parent may be sibling a co-trustee?
If you have a trust is the entity that owns it. The trust is controlled by the people that you appoint as trustees over the trust. That trustee now has created an obligation similar to what we're talking about here with the healthcare surrogates, where they are what's called a fiduciary. They have an obligation to the party. That means they're legally obligated to treat that person in a fashion as if they were doing it for themselves.
But what about the beneficiaries of the trust? Do they have now an obligation to do accounting?
The trustees have an obligation to sit down and keep proper accounting records. And the beneficiaries of the trust would have the right to sue the trustee if they breached the duty, if they took out money that they were not authorized to take out.
And does the sibling have an obligation to tell the other siblings who the attorney is that wrote this thing while the person's,
It depends upon if that person has any rights under the trust. If you're a beneficiary under the trust, you can sit down and technically and sue for an accounting. You can do for other things, and during the course of discovery, find out who it is if they're not telling you who it is.
while the parent's alive?
It depends upon if, while they're alive, they don't have to tell them anything because they're doing is acting as the trustee, unless you can sue that they're breaching the obligations under the trust.
But what if you don't have a copy of the trust and you don't know who the attorney is? All you know is that all the bank accounts are being held in trust and the sibling has control.
You could sit down and go into court if you believe that there is a breach of some obligation to you under a trust and try to convince a judge to require the discovery of certain information. But they're not going to have any obligation to give you anything, absent you going into court and having a court order to give you some information.
Since we both have nonlinear thinking,
You want me to go back my slide?
No, you don't have to go back to the
Okay.
slide. But Jim Kramer has nonlinear thinking. You were talking about, you don't have to, you were talking about healthcare and having respect for the patient. What about if your standards are different than the person you're taking care of? For
You
example,
have an obligation to treat the person as if they want to be treated, not as you want to be treated. That's what a healthcare surrogate is supposed to do, but the most important part is getting the surrogate to be somebody who thinks the way that you do, or at least act the way that you want them to act. Because once the surrogate is in that position, the surrogate's going to do what they believe is appropriate, and there's no way really for that person to sit down and do anything about it if they treat differently. You've given that person the power. Whoever you give that power to, you got to make sure is going to want to comply with your desires.
So that person can technically say, like in modern society, we take a bath once, twice a day. But during the war, or in France, they took a bath maybe once a year in the 15th century. So if there's a dispute over something like that.
Okay. I'll just finish with one really fast. I'm saying, if a person is not being treated the way that they want to be treated or the way that health laws require them to be treated, another family member or somebody can report them to the appropriate governmental agency to say that this person is not being taken care of appropriately. But a person has the obligation to really take care of the person the way that they want it to be taken care of.
I'll go. I'm coming. I'm coming. I'm coming.
Let's try to generalize this and only do one question each. Not more than one.
Can I take one here? I think that maybe
think that the concern is, let's say that you are the caregiver for someone who has been affected with Alzheimer's, and maybe they don't want to take a bath anymore, or they don't want to take their, their medication, or maybe they want to do something that is against their safety, or then, are you supposed to, I think that's the concern of the caretaker. Are you supposed to follow because that's what they would have wanted? Not to take a bath, not to take the medication, go out in the street naked.
Okay, the problem you're going to have is when we have people that are affected by certain diseases, whether it be MS, whether it be Alzheimer's, or whatever else it is, we're going to have people that may not want to do things that are in their best interest. And a caregiver is going to have an obligation to sit down and do what is in that person's best interest. And it may even require the caregiver to sit down and possibly Baker Act or do whatever else it is in order to get certain things done that the person refuses to do, such as taking their medication. So caregivers are assuming obligations. Realize if you're assuming the obligation of being a caregiver, that you are going to have a legal obligation to make sure that the person is taken care of, or you may yourself wind up in criminal charges. They can be brought up on charges because you've assumed the responsibility for taking care of somebody. Now let's jump forward a little bit to the Family Medical Leave Act and realize that we do have some federal legislation that is out there that gives people the right to take off from employment at periods of time in order to sit down and take care of certain family members. We have these laws that exist on a federal basis as well as they may exist in your state that may give you additional rights. Now realize what the federal government does is they set forth minimum standards of what the law is. Realize that the state can't say that, well, you have this federal right, but we're not acknowledging it. Federal law preempts state law, but a state law can give you even more rights than you may have under the federal government as well. So the federal government sets forth certain standards, but realize everybody hears about the Family Medical Leave Act and they think that it's great. But realize that not all employers are required to comply with the Family Medical Leave Act because they may not meet the threshold of being involved in interstate commerce, which gets the federal government basis on there, or have the requisite number of employees inside of the organization. And I know Stuart's going to load the slides up on the website, so you'll have the ability to go through it and actually see what the actual requirements are under the Family Medical Leave Act. Now, this is what we started talking about a few minutes ago, saying, well, we need to choose wisely as to who we want to have. Realize that certain people might be great to take care of numbers. Realize that other people might be great to take care of your health. And realize that the same person may not have the same philosophy as you. That's why you might have inside of your will, when you have small children, a guardian for the children, but you might have a totally different person be the personal representative to take care of the administration of your estate. So I say, look at wisely as to what you want to do. I may want to give John, my oldest son, the power to take care of me on my medical decisions, but I realize John doesn't do very well in taking care of his own budget, let alone my budget. So I may want to have my daughter Sarah take care of the nannies, so I may give her the power of attorney to take care of my bank account, doing my checking for me and other things that we have as well. So that's why I like to distinguish, and I say I have my form of a power of attorney, which has all these paragraphs. Okay, I'm giving you these powers, and I'm giving you those powers. You have the ability to do that. You control your life while you're alive, and you have the ability to do so. So we have these other forms that are out there that are called durable power of attorneys that also may have the ability to give medical choices that are out there. But don't think that you need to sign the durable power of attorney, which gives one person the ability to take care of our medical decisions as well as our financial decisions. You can bifurcate or split off those roles to get exactly what it is to the person that you want to have that responsibility. Let me jump forward here. I'm skipping through all these slides because I'm not going to have the ability or the time to get there before Stuart comes and kills me. No, I'm going to continue going on. No, I'm actually one of those people that happens to love the questions because it gets you the more important of the information.
Craig, let's finish your whole presentation and then we'll go to Q&A, okay?
Okay.
Thank you.
I'll go back a few slides then. Yeah. Understand your right to be treated with dignity. Understand that that is the right and the obligation of both the patient and the healthcare surrogate. We have the right, regardless of discriminatory purposes, that knowing that the healthcare surrogate has the same rights as the patient once you give that person that responsibility. That includes giving that person the right on your behalf to refuse medical care and treatment. But note that a doctor might overrule those decisions because the patient does have greater say, and the doctor might actually say that the healthcare surrogate is not acting on your best interest. So it's nice to give over the power, but do note that the healthcare surrogate is never going to be quite as strong as you when it comes to the doctor listening to the person. We also need to make sure that the person can understand exactly what it is. It's great to have all these forms, it's great to have all these powers, but let's see, we're living here in an age where we have people that speak different languages. What good is it if I sit down and I draw up a form and the person who is signing it does not understand it? What good is it if the person who is receiving the form can't understand it? We need to make sure that the people really know what it is that they are signing, and we need to make sure that the person who is receiving the document has the ability to understand it as well. There is nothing wrong with actually having a translation of a document. You may want to actually sign a document in a foreign language. That doesn't mean that the doctor's really going to understand it either, but we want to make sure that the people truly know what it is that they are signing. I have another lawyer that works closely with me who was just completing and going through a review of things, and when talking with the person realized that they signed over a whole bunch of rights that they never knew they signed over. Because John went to the lawyer with his son. John doesn't speak English. John's son is there doing the translation. The document has been created, the document has been signed. John has given away a lot of things that John never intended on giving away. Is it legal? No. But then you go back into court and you start dealing with issues of fraud and a whole bunch of other things, which is not the easiest things to start doing in court. Let alone when it gets to the point when people are really going to realize this because John is now going to be incompetent or passed away. So what do you want to make sure that you are doing? If you have issues of language or whoever else it is, you want to make sure that the person that's drawing up the documents has their own translator. You go into my office, I admit I do not speak Spanish. My translations will be done either by a bilingual attorney along with me or a bilingual staff member, not a family member. I love when I have people that come to my office and start meeting with me and I start chasing people outside of the room. And then I get to explain the great issues of attorney-client privilege, saying, I'm sorry, I am here, I represent this person, that is the only person I can speak to, and if I have anybody else inside of the room, I've lost attorney-client privilege, so therefore, go away. I have had clients that have walked out of the room because I've required that. That's fine. But I want to make sure that whatever is being done is something that I'm agreeing, and that person who is meeting with me also agrees upon. Is there a question over here? I saw it. No. Yes, in the back. Hold on, Pat, you here?
Isn't it better to just do a last will testament?
There's totally different things. I'm glad you're actually bringing that up because that's actually where I'm heading to next. Last will and testaments take care of you when you are dead. It has absolutely no force, no effect, and means absolutely nothing while you're alive. You want to sit down and properly take care of your estate. You want to take care of what's happening now, what's happening later, and what's happening after we're gone. They're all different stages of our life. Because we're going to have stages where we cannot take care of ourselves. At some point, almost all of us, unless we're lucky enough and we just happen to have that little stroke and we die nicely and quietly in our bed. But unfortunately, that doesn't happen to way too many of us, where we sit down and we end up in a stage where we can't take care of ourselves, whether it be Alzheimer's, a disease, cancer. Unfortunately, we haven't got the cure-all of everything at this point in time. So we need to say, okay, I can take care of myself today, but I do not know what's going to happen tomorrow. I consider myself to still be young, not because any of the fact that I got this great AARP card that I like to hide and pretend it doesn't exist. But I do know that I cannot be confident that what's going to happen tomorrow. None of us ever know. So no matter how young we are, no matter how invincible we think we are, we need to sit down and actually prepare a power of attorney to give somebody power on our behalf. I have clients that do not trust anybody. They're my favorite clients in the entire world. Because they think like I do. I've seen all the negatives in life. So therefore, what do? I have my client that's getting ready to travel and leave the country. They come to my office, we can create the power of attorney form, but guess where that power of attorney form is? It's locked up in my safe in my office. The kids have no power or no control over anything unless I get confirmation that the person is incapacitated at the time and can't make decisions. I will do my own due diligence to make sure that that is truly the fact. I have it there, and I will only bring it out if it needs to be brought out. You have the ability and the power to do that. So if you do not trust, protect yourself and know you can't trust, but I have no choice. It's my kids. They're going to get it eventually. Well, okay. But do we want to sit down and end up with nothing in our bank account because everything went to the kids because they took it when I went on my cruise? And if you think that doesn't happen, I give you another real-life hypothetical, these things that scare everybody. I have one of my clients who had a lot of money, and had means had. He found this beautiful woman that he fell in love with. By all standards, a 12. And he sat down and they got married. They were together for a few years. She got the power over everything at some point in time. He went away on a vacation for business purposes. He's gone for a week. He came back. He had nothing. Everything was cleaned out, even the equity line on the house she wrote a check on, everything was gone, even money that he didn't have because she started taking everything out. She took off to go back to the country of her origin. Good luck in getting your money back. So you do need to realize that, especially when you get to know things, that you cannot trust completely, ever. Choose people wisely. I'm not sure you want to thank me. You probably want to sit down and nobody's going to sleep tonight after my conversation. Understand what your choices are. Make sure that the caregiver understands what your choices are. Do not hide. Do not conceal. Now, what about these other great things that we also get? The things that come pretty much monthly that we want to hide from? We love getting the checks that come in, but we hate the checks that go out. Well, understand also that we do not have the ability to understand every bill that comes to our office, let alone from our doctors. Again, we can give somebody the power on our behalf to speak with our insurance companies and speak with the doctors about the bills. But if you do not give the person the power, they cannot do that on your behalf. There are healthcare advocates that are out there. There are all kinds of professionals that can do this, but you may also want to have your family members have the ability to do it. To this day, I still sit down and I look at these medical bills. I can't understand them. My son just had some surgery and I got these bills. Now I'm going to have to sit down and distinguish and say, why am I getting a bill for X? We're insured. We paid our things. We paid our that. We have to sit down and try to figure out what these things are. My son doesn't have the ability, so he sends it to me, so now I have to figure it out. But these are the things that we need to understand and get the person that can take care of those things on our behalf as well. Now here's my slide that I hate talking about, but here's another thing that we need to sit down and pay attention to at all. What about restraints? And those are the things that we're talking about when the person is being physically strapped into a bed. These are medical things that do happen at times for medical purposes. What do we do about those situations? Well, we want to make sure that if we're being held and we're being restrained, that there is a verb purpose. Wouldn't we at that point in time want to make sure that we can get somebody that can speak on our behalf? So this is my main reason and my main saying that no matter who you are, you want to make sure that somebody always has a healthcare surrogate or a healthcare proxy on your behalf, because when you're constrained into bed, how are you going to get yourself help? And I have seen cases that have come through my law office at times where we start seeing these great pictures of somebody that has been physically restrained in bed at an ALF. Adult living facility. Or ACLF, or whatever you want to call it, a long-term care facility where you start putting people when they can't take care of themselves anymore. Those are some of the pictures and things that I saw that make me cringe. But those people can't defend themselves, and if they don't have somebody that has the power, those are the ones that are going to be abused the most. The healthcare surrogate form would give the ability for that person to make medical decisions, even gives them the power to go into court and get things done on your behalf. Okay, I was talking to somebody just before we started here today that was asking me about such things as advance directives. Everybody better make sure that you express your opinions as to what you want to have in the way of life-sustaining devices. Again, you can sit down and give people the power to make those decisions on your behalf as well. If you do not do so, and you do not do so in writing, they are not going to honor your wishes. So please make sure that if you just sit down and say you do not want to have a life-sustaining device, you do not want to have yourself resuscitated, your DNRs, all of those forms, make sure you complete those forms. Because that is where you end up in the cases, if you are looking back at historical cases, of patients that are being kept alive and the family members have no ability or no power to stop it. So of all the forms that you're completing, what do I want you to complete? 1, a will. Number 2, your healthcare surrogate. Number 3, your power of attorney, and if you don't want to trust your kids with it, find a lawyer or somebody that will lock it up on your behalf and protect it for you. And number 4, your advance directives. Complete those forms and make sure that people really understand what it is that your wishes state. It doesn't do a lot of good if you have your healthcare surrogate form, you have your power of attorney form, and you have all these things, and guess what? They're locked up in the bank safe. What good is it? They'll find out these things. Oh, that's really what they wanted to have happen to themselves, and they find out, well, they've already been buried. Well, they find out that the person wanted to be cremated. These things happen every day. When my attorney friend passed away, the first thing I got was a phone call from the kids saying, 1, that he had passed away because we were very close. Number 2, they knew that I was the attorney that drew up the will. And they're saying to me, did Dad want to be cremated? I think he did. I don't know. It's pretty sad when I'm getting a call from a family member asking me the questions about what Dad wanted. But as I said about Dad, everything was perfect. There never was a problem. Dad did not communicate, but fortunately his dad did communicate with me. And I had the relationship with the kids, notwithstanding the fact that the kids also happen to be lawyers. It's funny, but I will never say who it is. It's kind of funny but pathetic, but I'm saying this is what really happens in life. Most of the clients that I represent, I've represented for years. So the kids know me, everybody knows me. I had a lady that passed away the other day, the son calls me. It's great when you have that relationship and they know that I have all the forms, but it's only good if I have the forms. Because even clients that I have great relationships. One of my closest friends keeps talking about getting his things done and he's not of the greatest health, but yet he has not gotten off of his couch to sit down and do what it takes to get it done. I can't tell you how often I brought it up, but eventually I just bang my head against the wall and I give up too. Do what it is that you have to do before it's too late. Now realize that when you give the power to somebody, that person has to have the capacity to sit down and have the power. What do I mean by capacity? Well, it does not do me a lot of good, even though my child happens to be brilliant. My child is Doogie Howser. If anybody can remember the TV show, I think he was 14 or 15 years of age and he's already in medical school. Okay, Doogie still is powerless, no matter how bright he is, because he has not reached the age of majority. So you may have a young child, that child may be brilliant, but that child can still not legally do things. Another thing I'll tell you, even though it's totally off topic, it's great when you want to plan your estate and you want to sit down and leave your house to your children, but please make sure you never put your child on the deed to your house that's under the age of 18, because guess what? You want to sell the house? You need to go to court and get permission to sell your own house, because your child's now on the deed. Understand what your powers are, understand what your rights are, and understand what it is when you give up certain of your rights. Now realize, even though you create these great legal documents, you are allowed to change your mind. I have a client that I actually fired not too long ago. Yes, I do fire my clients. That's also why I'm no longer number 326 inside the law firm, because I'm not going to listen to anybody else above me anyhow. So we have these great clients, and our clients may want to change their mind. But if you have a client that is changing their mind too frequently, what does that mean? That probably means that that client doesn't really have the capacity anymore to make up their own mind. And the last thing I want to be done is dragged into court and saying, did she have sound mind? I'm not a neuropsychologist. I only know so much. And we often know people that are lucid one minute and they're not lucid the next. Unfortunately, that's a fact of life as well. So understand that you can change your mind, but you're going to get dragged into court if you're changing your mind every year, every 6 months, or whatever else it is, where you keep changing your will. Because somebody's going to show that, okay, Your Honor, here's 14 different wills. Do you think this person was sane? And the judge is probably going to say, you're right, the person was insane. So therefore, the will is going to get thrown out. So it's nice to change your will. It's nice to keep things current. But let's make sure there's a reason to change your will. I love when I have people that come to me and say, okay, I just had another child that was born. I want to change my will. And my question is going to be saying, why do you want to change your will? Because we drafted the will that includes children that are subsequently born. So therefore, there are reasons to change a will, but there are also reasons not to change a will. Make sure that there's really a legitimate reason for a change that's being made. And if you're getting mad at your kids every 6 weeks and you keep changing your will, the will is going to be a piece of garbage. Living will. I'll be taking questions and promise in just a couple minutes. I'm getting to the end of it. A living will is a great document. Declaration at the time I'm incapacitated, I have a terminal condition. I have an end-stage condition. I am in a persistent vegetative state. Therefore, what does that mean? I do not want to have these artificial devices keeping me alive. That's where we had somebody over here that brought up the question, well, I have somebody that's going to keep me alive no matter what. Don't give that person the power. Create the living will and give that power to the person that will comply with your wishes. The healthcare surrogate, we can sit down and use pretty much any competent person over the age of 18. We talked about the need for that. Again, if anybody is here in this room or anybody that is watching me online lives in the state of Florida, or if you live in a different state, go to your state website and see if those forms are there where you can get these great forms for free. Why are you going to come see me and get a nice charge for hundreds or more dollars when you can go get them for free? The State Bar website. If you're here in Florida, since you're here in front of me, I'll take a guess that it's the Florida Bar. If you go onto the Florida Bar website and you put in healthcare surrogate form in that search item, you can get that form designed by healthcare certified lawyers that can sit down and give it to you at no charge. It's actually floridabar.org. And for those of you that are in the other states, go to your state website. I can virtually guarantee you that in many of the states you're going to find those same forms written to your state law and for free. We have the durable power of attorney. That, again, is something that works only during the course of your life. I can't tell you how many people I speak with that think that a person has passed away and they show up to me with the power of attorney form and I tell them, sorry, it's not worth anything anymore, and they cannot believe it. It is only, again, good during your lifetime. The will kick in after you pass away. But realize also some more free advice of ways of taking care of things and keeping things away from Uncle Sam. You do have the ability inside your bank accounts, your 401ks, all these other great things that are out there, and designating a beneficiary. What does that mean? That means that beneficiary can show up with a death certificate to the bank and take the money out and avoid probate. There are lots of ways that you can sit down and take care of your assets in different ways. So I strongly encourage everybody to sit down at some point in time and speak with an attorney that specializes in estates to sit down and help you plan for your estate in ways that can best suit your needs and protect your money. Again, DNR forms, do not resuscitate, a great form that can sit down and do things. But realize that each of these forms are independent of each other, and a DNR form, a do not resuscitate form, is different than a living will. Yes? How? A DNR form means do not resuscitate in the event you're having a heart attack or whatever else it is. I don't want to have this anymore. That's different than saying, okay, I do not want a life-sustaining device. Express your opinions in writing. Communicate them to people that you know and you trust that will comply with your wishes. Again, do not create these great legal documents and lock them up in your safe in your house, your safe in the bank, or wherever else it is, because it does no good if nobody knows what they say or where to get them. And with that being said, any questions that are left?
Yes, I have a question here.
Really? I thought I said everything already.
Question here. I have
have a question. I have a question. I do have a question.
Okay. Oh, you got the microphone too? We're in good shape. Okay.
On as far as a will, if you're, because I have a, anyways, if you're married, can you still on your will you give everything to somebody else?
You can, but understand that your spouse is going to have statutory rights to certain things, even if you will it someplace else.
I have a question over here, Craig.
Yes, what about special needs trust? Do you do those?
Do I do those? No. But I have some great friends that are tax attorneys that I specialize in doing those kind of things, because there are nuances in the laws, and the laws change every day. And for people that need a special needs trust, I'd much rather get you to a tax attorney that understands every one of the tax laws, including the ones that are yet to be written that are already being negotiated. And I have some very close friends from back in the days when I was number 326 that do nothing but tax law. So I would not recommend that you go to a special needs trust to an estate attorney. I would really recommend that you go to a tax attorney for that.
Can a doctor override a healthcare surrogate if there's a living will or an advance directive?
Yes. Should they? My opinion, probably not. But if they find that you're doing something that they do not believe was in the patient's best interest or what the patient had expressed to them, I can virtually guarantee you that I will find many doctors that will say, I'm not listening to what you're saying here, I need to keep this person alive, the person still has the ability. It happens all the time, unfortunately. All the way in the back.
The question is about the, you had talked about making sure that we have somebody who is there to speak for us if we're not able to speak for ourselves. And it brought up memories of times where we have, those of us with the MS folks with really bad confusion or states of confusion, and we may be lost or confused or things like that in public areas. Is it a good idea to put the name of that person on and their number on an alert bracelet?
There's nothing wrong with doing that. I would actually, if you feel comfortable in doing something like that, there's not a problem in doing so. I mean, you're expressing your interest, whatever there, and we haven't reached the point where I think eventually we'll get, which is scary, that you'll have this little microchip in your body and they sit down and scan it and it has all your information. But we're not there yet, but someday we probably will be. But there's nothing wrong with having the equivalent of a medical alert bracelet or a tracker. I mean, I know they do things similar to that with patients with Alzheimer's and other things where they have the ability to help that person be found. So I'd actually encourage it. I mean, the biggest problem I find is people thinking that they have the power and they haven't really given somebody that power to take care of it. And that's what scares me more than anything else. Because we have domestic partner situations where some states may sit down and honor things and other states will not. I mean, we have so many situations that are there, but the benefit we have is once we do something so simple as complete a form and sign a form, we can take all of these problems away. And you have the ability to create these forms at no charge if you have an internet access and a printer. And there's nothing that bothers me more, and that's one of the main reasons when I was talking with Stuart one day about how can I assist. I mean, because I know Stuart for years, helped him form the organization, and I care about the organization, I care about the people that are affected by it. But it hurts so much to know how easy it is to take care of a problem and people still fail to do so. And when people tell me it's the charge, and I sit and say, okay, you go to the website, now it's free. What's the reason now? And the reason is we are all internally refusing to deal with a fact that we are not immortal. And that's as simple as it is. We all think that we have the ability to live through and survive everything. But yet we have children that pass away because they sat down and their heart had an issue that was not diagnosed. They had all kinds of things on the news about this that are going on with athletes. We have athletes that fall dead on the basketball court, people that appear to be in perfect health, but yet we don't sit down and realize that we are not immortal and that we need to sit down and take care of things. Because if we don't want to face it for ourselves, wouldn't it be nice to take care of it and helping it with our family so they don't sit down and end up in fights? With one children saying one thing and one child saying another thing? Or all these other situations that happen, somebody happens to leave their kids with somebody and they end up having the husband and wife are traveling together. Now you have two different sides of the family that are fighting for the custody of the kids. Wills take care of these things. And it's not terribly expensive to do so. I mean, if you don't want to go to a lawyer, you can sit down and go online and get some of these forms done. I don't really recommend that. But you have all these websites that are out there. To me, they're not the world's greatest because they're just plugging in the details into a form and they're not really being written to what the person specifically wants. But that's still better than nothing.
Have a question here. Comment and question. I agree, but it's one of the hardest things to do is to do the wills because nobody wants to face, that part of their life coming to an end. The other question I have, if I have a will, an advance directive and all that, but I move from one state to another state now, does that need to come from this other state, and do I need to redo the whole package and have it done here in South Florida? And is there a way to put in there that you do not want to be put in a nursing home or something like that, so people know you do not want that? Is that legal? And where does that go?
A state is required to recognize the forms that are created in another state. But with that being said, we have some people that may not recognize something that was done in another state because they have never seen it before. So would I encourage somebody that moves from one state that's going to go into another state to create new legal documents? The answer is yes, but the answer should be no. Because if they sit down and see, and the example I give is, in Florida we use the words healthcare surrogate. I am aware that other states call it a healthcare proxy. If you go to somebody that does not recognize it or understand it, because realize not everybody is the sharpest tool in the shed. Hate to say it, but isn't it best to get the form that's here in the state that people are going to see and recognize? So, would I encourage you to do it? Yes. Are you required to legally? No. Now, insofar as your desire to express your wishes, it's nice to express your wishes. I hope that the people will comply with your wishes, but they cannot sit down and say, okay, I'm keeping mom at home and I'm not putting her in a home because we don't have the money to take care of mom, because we want to make sure that there's plenty of money left for us to take care of ourselves after mom is gone. I'm being honest and morbid at the same time. It's the truth. I know of examples where I'm seeing things being done, and I firmly believe that it's because they want to make sure there's as much money left for them at the end as possible. That is a reality, but unless somebody's going to step in and interject and bring this into a courthouse and say that this is not what is supposed to be done, it's there. And you talked about, lastly, one point that you made that's 100% wrong. Putting in your will that you don't want to go into a nursing home, the will only kicks in when you're dead. So therefore, it doesn't mean anything when you put that inside the will. So therefore, you want to express your wishes to your children. I encourage you to create a trust or whatever else it is and give the trustee the power to make sure that your money is spent the way that you want to have it spent.
What if you don't have children? Should I talk to my niece who's a doctor or somebody? And because I do think, because I have family, married 64 years, and they're still at home with their spouse, but we have around the clock care, plus the two kids are right there all the time. But like if you don't have children, who do you go to? Your nieces and nephews?
You go to the person that is the closest to you. And that person may be a friend and not even one of your relatives. I sat down, I have a friend that used to work with me. And she has no children. She was married, but she got divorced at a young age, never had any children. Her estate is being controlled by a friend. There is there a bequest for her family members? Yes. But she chose not to give it to her nieces and nephews and instead chose to have everything being taken care of by a friend, because that's the person that's really been there and taking care of her. That's the person she goes on vacation with, and that's the person that she's the closest to. I can't say what's right or what's wrong, but I've never had the ability to keep my mouth shut for my personal opinions. I drive my clients crazy because even though they're in business and I'm representing them, I give my business advice as well. Because that's who I am. I can't shut up. Which is probably why I've been speaking for over an hour already. And Stuart hasn't hit me yet. He started me 10 minutes early too. Any other questions before Stuart says shut up? Yes, Stuart. 5 minutes. I got a 5-minute warning, so we got about time for 15 questions left because I can probably cover each in about 3 seconds.
Tell everybody your email address, please.
Oh, do I really need to do that? Okay. My email address is cdorne@dornelaw.com. So that's Charlie, David, Orange, Robert, Nancy, Edward, at David, Orange, Robert, Nancy, Edward, Larry, Apple, William.com. I know, I speak too fast. I'm born and raised in Miami, but my family's from Brooklyn. I apologize. Or I'll be even more dangerous and drive my secretary crazy. If you want to reach me at my office, the phone number is 305-531-7890. That's only my cell phone because I have about 175 messages in there and I never listen to them, which is why my cell phone message says, do not leave a message here, but Stuart still leaves messages there. Any other last questions? We got about a minute or two left.
Wait. You have a question? I got to get a mic.
We got it.
All right, you guys go first.
Okay, thanks. My question is, if you give somebody power of attorney, can they use that power of attorney to change your beneficiaries on your will or any other financial investments that you may have in which you have designated
If you
your
give somebody a
beneficiaries?
power of attorney, depending upon what that power of attorney says in it, you may be giving them the power to sit down and leave you bankrupt.
So they can change your beneficiaries.
They can go into your securities accounts with your 401k and change beneficiaries if you give them the power to do so. Understand what those powers are and what you give them, and be careful, which is why I said I designed my form box by box by box so they can say yes or no to whatever it is that they want. And there are certain things that require to be specifically initialed under certain state laws before you can give that power versus just giving a global power. Because in the old days, you used to have this one paragraph power of attorney that gave everybody the power to do everything, and people may not really have realized what they were signing, that were used to their disadvantage. So fortunately, some states are becoming progressive to limit some of those rights from these global powers.
By the way, in case you forget any of what was just spoken about today, this will be on our YouTube channel within a week, hopefully. So you'll be able to go back, and we're going to divide it into 3 segments. The first panel, which was the 2 neurologists, the second panel, which was the psychologist and the Social Security disability attorney, and then the third one will be of Craig. So you can choose which one you want to go to. Next question.
When I asked you before, you went into something afterwards about the will. Can the person I designate on my will be out of the country?
You can make
in the state of Florida? I mean,
you can make a Florida will and give anything to anybody that's here in the country or not in the country. But I think this is the more important question. The personal representative of your estate, at least under Florida law, I have to give a major caveat on that because I don't know what the laws are in the other states, needs to be within a certain listing of your lineal descendants before they can be a personal representative that lives out of the state, but inside of the state, it can be anybody. I've actually seen personal representatives be banks. So it doesn't necessarily even have to be a person. You can give the power to sit down and say my estate is going to be administered by a bank, because there are all kinds of trust departments inside things in banks that have been given certain powers. It can be a friend. It can be an attorney. It can be whoever it is that you want to give the power inside of the state, but outside of the state to serve as your personal representative needs to be certain blood relatives.
Any other questions, Maria? Okay, we got one more here, and then
we get back to Dr. Burke, so I can sit down.
No, and then we got other things to do.
Okay, my question is about the form. Like you said, things happen in life, and you have your husband.
You're going to have to start over because I really didn't hear that at the beginning of it.
Things happen in life, and you have your husband as the person to take care of you, but you get divorced, and you get a new one. Which one is valid, the old one or the new one?
If you create a form, that's actually a phenomenal question. The form that matters the most is the last one that is created. You have the right to revoke a prior will, a power of attorney, all of these different forms that you've given out. But the problem you generally have with these things, and which scares me the most about these things, is technically you may revoke it, but how is the person that's going to see a nice, neat, notarized document going to know that it was revoked? Until somebody shows up with one that has a later date than the one that you've presented. Which is why power of attorney forms, to me, are some of the scariest documents you can ever create, because you're truly trusting that person, which is why I even had clients that sit down and says, I'm giving you this form for you to hold because I want to make sure that it is only used in the way that I'd want it to be used. You're giving people power, you're giving people rights. Can you go back and sue that person that just went and closed out your 401k because you revoked that power of attorney that they've used? Yes, but getting the money is a whole nother thing, and I can't tell you the number of times I've gone into court and I tell my client ahead of time, yes, I'm going to get you this great piece of paper with it's called a judgment. Yeah. But I can tell you what you can use that judgment for, and I'll be, even though I'm on video, I'll say it anyhow, it's the equivalent of toilet paper. Because it's only worth the ink that's on it, which is worth nothing if you can't find the money. So be careful with who it is that you're giving the powers. Do I encourage every single person to have one? Yes. But I would be very careful as to who you're giving that power to. And you may want to have somebody hold it rather than giving it to the person to have the ability to use it against your wishes.
So we want to thank you all, and we want to thank again, before we get into the nitty-gritty here at the end, we want to again thank the sponsors for this program, the primary four that made this program happen. We want to thank Genzyme, a Santa Fe company, Mallinckrodt, Teva Neuroscience, and Genentech. And I say thank you to all of you for attending, because again, this couldn't even be possible unless you were all here to fill these chairs. And we do want to educate and provide you all this information, resources. This is what MS Views and News is about. So now we can say goodbye. Have a great day.